Okay, it looks like all the members of the committee are here, so I think we're going to go ahead and get started, and I'm going to call. Oh, somebody haven't said something? Okay. All right, in that case, I'm going to call to order the Land Use Committee meeting for December 2nd, 2020. And may I have a roll call, please?
Commissioners Thompson.
Here.
Weingrad.
Here.
Bowman. Vehi.
Here.
Vaughn.
Here.
And Tom Bowman, I see you there, but your microphone is muted.
Present.
There you go. Okay. Our first order of business this evening is to consider the approval of minutes. So I will put forward a motion to approve the Land Use Committee minutes of March 4th, 2020, and the special meeting on June 8th, 2020. And I so move.
Second.
All those in favor? Aye.
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 Approved. There are no presentations tonight, although there is a brief announcement. Given Commissioner Luker's departure from the Board of Commissioners, there's been a slight change on this committee. We are welcoming Commissioner Vaughn to the committee, and we are moving Commissioner Weingrad to the vice chair role. And that's it for the announcement. There is no unfinished business tonight, and on to new business. We have two agenda items up for consideration. The first agenda item is LU-01-121020, which is to discuss and consider an ordinance to create and enact Chapter 130, the residential rental license permits. And that ordinance has been crafted and put together by Solicitor Clark. So I'm going to ask Solicitor Clark to weigh in and kind of walk us through what's contained within the ordinance.
Thank you, Mr. Thompson. As you indicated, we have drafted this ordinance for the commissioners' consideration. The draft ordinance would establish a registration and licensing program for all residential rental properties within Abington Township. Registration would be required for each property every year. The registration would require a tenant list, copies of leases, along with contact information for a designated resident agent who would be required to live within 12 miles of the township, so that the township had a way to deal with any emergencies, and in the event of any emergencies, contact this designated resident agent if information were needed. Inspections would be done in a tiered fashion. The proposed ordinance has 6 different classes of residential properties, rental properties, excuse me, that I'll go into in a second. Class 1, 2, and 3 properties would be inspected every 4 years, and class 4, 5, and 6 properties would be inspected every 2 years. The inspections would be to ensure compliance with a variety of township codes, particularly property maintenance requirements. We're not adding any new codes or new requirements. It is essentially, these inspections are for compliance with the existing codes. It'll also condition the permits that landlords provide regular maintenance, such as garbage removal and snow removal from their properties. As I indicated, there are 6 classes. Class 1 is single family dwellings occupied by a single family. Class 2 is a single family dwellings occupied by other than a single family, and that is for less than 1,000 square feet of habitable space. Class 3 is single family dwellings occupied by other than a single family, and that is for greater than 1,000 square feet of habitable space. Class 4 is multi-unit rental properties consisting of 4 or fewer dwelling units. Class 5 is multi-unit rental properties containing 5 or more dwelling units. And Class 6 would be defined as rooming houses. Licenses can be revoked for non-compliance or if there are other issues with the property, such as drug possession, use or sale, underage possession of alcohol, disruptive conduct. The ordinance does contain a complete list of all of the infractions which could result in the revocation of a business license. These, I guess, two final comments. These ordinances are in many municipalities, and the one that we have crafted is based off of another Montgomery County municipality. We are comfortable that this will survive any potential legal challenge. And secondly, very often with these ordinances, the question arises as to whether or not by doing this inspection, we're not sort of adding another layer of potential liability for the township. And it is not adding any additional liability. This is essentially, if we are carrying out our governmental functions in the proper manner, we are shielded from liability as we are in all instances.
Great. Thank you, Solicitor Clark. I'm going to open up comments for the committee, and I'm just going to ask my colleagues if they could to please use the raise hand button at the lower right panel, if you could. So are there any other comments from the committee? Commissioner Bowman, go ahead. And you're on mute, by the way.
Yeah, hi, Mike. On the, it sounds fine to me. I think it's due because I think a lot of rental units have kind of slipped in under the wire and never been inspected, whatever. That requirement for an agent within 12 miles of the property, that'll survive muster. That'll survive too. I mean, that sounds a little much. If you like live in Bucks County and you own a couple of houses down here with rental units.
Well, it has to be someone who is considered, and the language in it is a designated resident agent. It doesn't mean that couldn't be somebody who's actually living in the place. It doesn't have to be the owner. We do realize that sometimes registered owners live much further than 12 miles outside of Abington Township. But we want someone within 12 miles who's a designated resident agent who, in the case of an emergency, can give our first responders access to the building, can identify who's living there, can identify if anyone in the building has any particular issues that we need to be aware of. So it doesn't have to be the owner. It just has to be a designated resident agent.
Okay, thanks.
And Solicitor Clark, this just as the ordinance was mirroring another ordinance within the county, the registered agent thing, that's something that's been used elsewhere as well, I'm guessing?
Yes.
Okay, so that's not uncommon.
No, it's not. And again, it's within the ability of the municipality to set a requirement like this so that there is someone who, in the case of an emergency, they know who they can reach.
Okay, thank you. Commissioner Vaughn, go ahead.
So this would be like if their property manager lives on site or close by, basically.
Correct.
Okay.
Correct.
Commissioner
And sometimes in multi-unit rentals, there is someone, who may be referred to as the superintendent or the property manager who lives on site, so that person could qualify. Doesn't have to be someone with an ownership interest.
Commissioner Vaughn, is that all for your comments?
Yes.
Okay, thank you. Commissioner Weingrad, go ahead.
Thank you, Mr. Thompson. The How many units are we talking about here? I mean, is the inspection of these units, is it going to require a full-time new employee? Can the inspections be done by current staff? And the second part is, and maybe it's connected, is what kind of fees are we talking about for these rental licenses?
Manager Manfredi, do you want to try to address this one?
Yes. We have not, until you design the program, it's going to be difficult to determine who's going to do those inspections, whether it would be a third party, whether it would be fire. I think that, I'd really be interested in hearing, whether it's tonight or after this meeting, Fire Marshal Rohr's thoughts. But I know this was something, in talking with him, that this was looked at before, so he might have some ideas. But our initial discussions were either third party, and then it would, or fired, or a combination of both. And fees would be dependent upon the frequency of inspections and undecided at this point. Commissioner, if you wanted to call on Fire Marshal Rohr.
Sure. Fire Marshal Rohr, any comments?
Hey, Commissioner, thank you. Currently, I'm reviewing the tax records. There are over 1,150 current rental properties in the township. I am breaking down that list of how many units are actually in each of those, whether they're single, 200, 300 unit apartment buildings, what have you. But just, I heard the question, that gives you a ballpark. We're looking at 1,150 properties. 4 unit and above apartment buildings, we currently do an annual fire safety inspection. However, we do not go into the individual living units, as that is a person's castle. We do common areas only, fire protection systems, heating, ventilation, things of that nature. We looked at this in 2011 and had proposed an ordinance 1994 that not only covered the rentals, but also some of the resale on residential property because of property maintenance issues. So it is a large project to undertake. I see a major benefit in it, especially we get the opportunity to look at some of the living units. 99% of our fires in apartments or rentals are in the living units, not in common area. So I can see this as a big plus for us and safety for the residents and our responders.
So Chief, so currently the fire code does not allow you to go into individual units?
We do not go into individual living units, no. We proposed that back in 2011, and that's been shot down right now. So.
Okay. I was just going to ask a question about, maybe this is for Solicitor Clark, about, I have never seen an ordinance that required the name of the tenants living in the property. I just haven't seen it. I can see that, I guess there'd be a benefit just to know who's there, right? Is that the whole point of it?
I believe that is the point of it, Commissioner Weingrad. Yes.
Yeah, I just never seen that. Okay. All right. That's all the questions I have for now. I would say this. I'm looking at the definition of a tenant, and I don't know if this accounts for family. So, for example, there could be a number of families out there that mom and dad own the house, but allow the daughter, son, granddaughter to live there. I just wondered, maybe that should be an exception to this. because they may not be paying rent, and it may be just a family home. I think that's something to consider. The other thing is, and I do a little bit of Philadelphia landlord-tenant work, and in that ordinance, the landlord cannot collect rent if they do not have the proper licenses in place. So that may be something else to consider as part of this, sort of an incentive for landlords to comply with this, should the need arise to file either an eviction or for money for non-payment of rent. So, thank you.
Okay. Thank you, Commissioner Weingrad. Commissioner Vahey, go ahead.
Thank you, Chairman. I'm going to try not to echo too much of what Commissioner Weingrad said, but my questions do also come from experience with litigating landlord-tenant issues in the city of Philadelphia, and the protection that's given to the tenant when a landlord's not in compliance is a wonderful shield for bad situations. And I'd like to see that implemented here if there's agreement on that point. Not just the inability to collect rent, but also the inability to kick somebody out of a house if the landlord's not maintaining it to code. The one thing I'm a little confused about, I like the idea of classifications of properties, but I'm not seeing how that's actually being how the classes are being treated differently under the proposed ordinance. Solicitor Clark, why are we having those 6 different classes?
I believe that most of the classification is based on the inspection time frame.
Okay.
And I believe, if I'm not mistaken, that in the...
Yeah, I see it.
Yeah.
Okay. And then the fees would be subject to a subsequent ordinance or resolution on the board?
Well, if you're going to adopt this, I would recommend that you leave the fees generally, so you don't have to amend your ordinance every time you want to change the fee, and that it simply be done by the yearly adoption of your fee schedule at the beginning of the year. So the ordinance would reference the fee schedule, and then each time you wanted to change it, you would just do it by adopting the fee resolution. This way you don't have to go back and amend the ordinance each time you want to change the fees.
That makes a lot of sense. Goes again to Commissioner Weingrad's point, if we need to hire somebody to satisfy this role, and we don't know how burdensome it would be, those fees are going to be pretty important to calculate and adjust. And then what kind of taxes do we collect from landlords? Would this come under EPT, or does anybody know the answer to that? Just, it's instructive to the fee question.
That's not a me question.
I know it's not a you question.
Manager, do you have that info?
It does not need to be a tonight answer either.
I think once Fire Marshal Rohr finishes populating what he's working on, we can cross-reference against those properties and get a better idea and answer that question.
Okay, no,
We
that's
do
fine.
have that, yeah.
But rental fees, they are subject to some kind of taxation in the township, or are they not?
Yes, they are.
Thank you.
Welcome.
I think it's a great idea. I think this ordinance is very well done. My preference would be to hold it for another month to discuss some of these ideas further. But I think ultimately we can come to a really good product here.
Great. Thank you, Commissioner Vahey. Commissioner Myers, I see your hand is raised, but I saw Commissioner Bowman, who's on the committee, had his hand raised as well. So I'm going to call on him first, and then I'll get to you. Commissioner Bowman, go ahead.
I wonder whether a yearly inspection is too much for some rental units. I am keenly interested in having an inventory and certainly having them looked at, for safety or for, obviously for the fire and any other reason, habitability, whatever. However, a yearly inspection sounds a little much to me. Certainly down the shore, I rent every year in Sea Isle, and they all have to have that sticker on their window saying I registered with Sea Isle to be a landlord this year. I don't know what that entails. Maybe John does down the shore. I don't know whether I don't think they come in every year. I think you just have to register every year after, I guess, an initial inspection. But yearly sounds. How many townships have this, Mike? How many have yearly? That seems a little much.
Commissioner Bowman, we're not inspecting yearly. We are requiring you to register yearly. And then the multi-units have to be inspected every 2 years. And the smaller units, single-family homes and the like, have to be inspected every 4 years. And I think the 2-year, 3-year, 4-year time frame for inspections is pretty consistent with what we've seen. The yearly registration is also very consistent with what we've seen, because the township wants to have an ongoing list of who the rental properties are from year to year. But the inspections will only be every 2 years or every 4 years, depending on the class of property.
Okay, thanks.
Thank you, Commissioner Bowman. Okay, I'm going to open it up now to the rest of the Board of Commissioners, and we'll start with Commissioner Myers.
Thank you. I'm only addressing up to class 4. And I just would like to state, I no longer own any rental property in Abington Township. So this is not self-serving. I find this resolution to be very restrictive. I feel like we're punishing the many good landlords that there are in Abington Township for the very few bad ones. Just like any profession, you have a few bad ones out of a lot of good ones. Landlords do pay taxes on their rental, and they are really, in the most case, small business people, very small business people, and this is going to hurt them. You have no way of knowing exactly who you're renting to. You go by a credit check, and this could be a good tenant, a bad tenant. You don't know. When I did own property in Abington, we had a tenant for over 13 years. How many times would that in 13 years, would that have to, with one tenant, would that have to be inspected?
Commissioner Myers, my understanding is that that would depend on the type of unit, but if it's a class 1, 2, or 3 unit, if a tenant was there for 13 years, that it would be more than likely 3 times that unit had to be inspected.
3 times in 13 years?
Correct. Yeah, if class 1, 2, and 3 are inspected once every 4 years.
Oh. I'm not really understanding the need for this. I'd be really happy if someone could demonstrate a real need for this, and how many commissioners have had a problem with this. Okay. Sorry. And how many commissioners or police department or code have had a real problem with landlord-owned properties? And again, I'm only going up to class 4. I'm not talking about multi-residential buildings. I'm talking about the single-family home. I'm talking about the occasional single family with a rental apartment upstairs, that kind of thing. Because in the ward that I represent, there's a lot of that.
I agree with that, Commissioner Myers, and it's that type of unit that prompted me to bring this to the committee of the whole last time we spoke about this. I've had, this is a fairly frequent occurrence in Ward 6, and it typically has to do with single family dwelling units rather than the large apartment complex that I've also had problems with in this ward. Like I said last time, I have a single family dwelling where there was a hole in the exhaust breaching in the basement that was dumping carbon monoxide into the house, and that went undiagnosed for years. The only way that that tenant found that issue was because they were offered to purchase the property from the landlord, and they had a home inspection agent come in and take a look. That's just one example. I'm sure there are other examples out there, and this is not the intent of this ordinance is not to put down the landlords that generally take care of their properties. This ordinance, in my opinion, won't put an added burden on landlords that do maintain their properties, because if they're maintaining their properties, the odds of any kind of issue being flagged via inspection are probably pretty slim. There is some administrative paperwork that does add a little bit of a burden to their job, and there is an annual fee, which I understand, and we're working to keep that as low as possible. And we understand the inconvenience of the inspections as well, and that's why we've moved them from either annually or on turnover to every 4 years or 2 years. But there are life safety issues out there. I do agree. I think the vast majority of our landlords are good business people. I don't think they have any ill intent or malice towards the community. But we do have some instances out there, at least in Ward 6, and I'm sure other wards as well, where problems do occur. And we need to address some of these life safety issues.
Well, I'm in complete agreement with you there, but I really think that they are property maintenance issues, and that could easily happen in a privately owned home with the owner occupied. I'm not quite sure that I'm seeing the difference.
In my opinion, that, as a homeowner myself, when I purchased the home, that's something that I implicitly agree to. I agree when I purchased the home that I am responsible for maintaining the home and for taking care of it. And then I own everything within it and outside of it. And if something breaks, I need to fix it. As a tenant, I don't necessarily have that same protection. I rely on the landlord, and if the landlord doesn't take action, then the tenant generally finds himself in a bind. And this hopefully gives them a little bit of protection and allows us to make sure that these units are being maintained and that they're safe for those tenants. I'd
like to see this ordinance. I understand exactly what you're saying, and I would like to see this ordinance make it easy to step in that kind of situation. But it seems in order to be proactive, we're being way over proactive, and there are situations where you have to be reactive.
Okay. Is that the end of your comments, Commissioner Myers?
For the moment, yes. Thank you.
Okay. Thank you. Commissioner Spiegelman, go ahead.
Thank you so much, Chairman Thompson. I want to say first that while I absolutely do understand and respect Commissioner Myers' position and concur that the vast majority of our landlords of all types and classes are good and responsible ones, I can tell you that in my time as commissioner, I have run into this issue in multiples of the classes listed in the ordinance. I know we've talked about this, but I mean, you're asking, Commissioner Myers asked what other commissioners have seen this. I absolutely have seen this, and again, in various types of rental properties. I have long found, although I'm not an attorney like some of our esteemed colleagues on the board and on this committee, I have long found in my time serving the residents that when it comes to rental agreements, unlike other states like, say, New York or maybe California, the Commonwealth of Pennsylvania, I think, tends to be rather landlord friendly in its laws rather than tenant friendly. So I'm always, my ears perk up at any opportunity to protect tenants. And I just want to say I'm in favor of this ordinance, and I want to give you a shout out, Commissioner Thompson, for your work in kind of bringing this issue up and shepherding it through, and of course Solicitor Clark for all of his work on that. But I just want to say thank you for bringing this forward.
Right. Thank you, Commissioner Spiegelman. All right, I'm going to call on Commissioner Vaughn next, and then Commissioner Bowman, you'll be after Commissioner Vaughn. Commissioner Vaughn?
So I've experienced this personally prior to being a commissioner, as a friend of someone who lives in Ward 8 that was having an issue with their landlord and not covering things that were going wrong. There was flooding, there was molding, there were different issues that she ended up paying for herself, and it wasn't deducted from her rent, and they didn't step in to do anything to assist. They ended up selling the property and kind of putting everything off on the new owners and not informing them of all of the other issues that were with the property. I also went through this issue that I think if this ordinance was in place when I lived in Mountain Vernon Gardens, which I'm sure John is very familiar with the situation that was happening, had there had been this ordinance at that time, all of the units that got affected from that particular issue, this wouldn't have happened, because this ordinance would have stepped in and been in place to protect the people that were living there through that situation. So I've seen it on all of the levels in multiple different situations, unfortunately. There are some good landlords that do everything they're supposed to do and step up, and there are some that just kind of like, I just want to collect the rent and whatever happens, happens, and it shouldn't be that way. So I don't think that this is too restrictive. I think that it's a good policy for us to begin, and I'm 100% for it.
Great. Thank you, Commissioner Vaughn. Commissioner Bowman, go ahead.
Yeah, I share some of Commissioner Myers's concerns in a general sense that I don't get complaints on this. I know, Mike, you have some more large kind of houses that lend themselves to division and rental units. I just share Peggy's concern that there's a court and there's an implied warranty of habitability in Pennsylvania for every rental unit. Now, I know that, now we're injecting ourselves into a private contract, a landlord-tenant contract. We have district judge courts, and if you prevail, your costs are covered by the loser. And things can be appealed, and there's certain protections for landlords and for tenants. If the landlord's not living up to the terms of his lease, you have legal recourse. So I share Peggy's concerns that we're kind of, we're getting involved in a big operation, and kind of, is it warranted? And it's a tough choice, I'd say. That's all.
Okay. Thank you, Commissioner Bowman. Are there any other comments this evening from the commissioners? Okay. Are there any comments from staff? Okay. Before, I'm going to go ahead and make a motion then to refer this conversation back to the next committee of the whole meeting for further discussion amongst the Board of Commissioners. And Solicitor Clark, I'm hoping maybe we can discuss and update the ordinance based on some of what we heard this evening before that next meeting. So I'm going to go ahead and make that motion. Do I have a second?
A second.
All in favor of referring this to the next committee of the whole meeting, say aye.
Aye.
All opposed? Great. Okay. We'll refer this to the next committee of the whole meeting. Thanks, everyone. We're going to move on then to the next item for the evening, which is LU-02-121020, which is a discussion to consider a resolution authorizing the township manager to enter into encroachment agreements. And on this particular agenda item this evening, I'm going to go ahead and make a motion to table this one. I think based on some new information today that we're not quite ready to discuss this one yet. And I'd like to move it forward to the next land use committee meeting. So I'll go ahead and make that motion. Do I have a second on that?
Second.
All right. All those in favor?
Aye.
Aye.
All those opposed? Okay. That brings us to the public comment portion of the meeting, and it looks like we do have one. So Grace, if you could let Ms. Lehman speak.
As usual, I am stunned. You have removed the 3 minutes after the item that we are to speak. Was that in the last package of speaking rules? Because we are supposed to speak on each item at a committee meeting and then speak openly for public comment for things that we might want to bring up that weren't on the agenda. So
Ms. Lehman, before you go on, I will take responsibility for that. I forgot to give you an opportunity to speak, and I apologize for that. Please go ahead.
All right, thank you. No, thank you. I was hoping it was not the latter. So I would appreciate the 3 minutes for that item and then the 3 minutes for public comment. So what I'd like to start with on that particular issue of the landlord-tenant inspections, I believe that there are many different ways that this can be done that address the concerns that were brought up tonight by commissioners and many concerns that were not even mentioned. And for example, one of the things that could be done is to have a registration and have the landlord himself certify the condition of his property and then provide that certification to the tenants for their signature and turn that in. And then only put your attention, as Commissioner Myers said, on the landlords that have a problem. And if we have a concern with, tenants don't want to turn in their landlord and that becomes a concern, then you could deal with that. But it would deal with a lot of other problems here. Solicitor Clark said that there was no added liability. That is absolute nonsense. There is, as Commissioner Bowman said, you are interjecting yourself in between a contract between a landlord and a tenant. And there is a great deal of liability and responsibility. Commissioner Solicitor Clark was completely wrong about the liability that we had with the colonnade, and it cost the township a literal fortune. We also have a very poor record of inspections from our fire department, which not only failed to inspect Mount Vernon and the Gallman properties and others. All of those are documented that these were not properly inspected. And in one case in the colonnade, there was a major deficiency on the heater and that property passed inspection. They didn't find that tag on the heater for the entire property until there was a fire. It's inexcusable. The same year that they failed so miserably, the fire department gave themselves a CFAI award for wonderful service. So we have a problem with the level of inspection. In addition, I sat in on the smoke detectors issue, where the smoke detectors were not being properly replaced at the time of sale of the property. And they invited the people that were letting that go through to be part of the solution. And the solution was to hire the former firemen to do the inspections. It's fraught with people looking the other way for one person while not looking the other way for someone else. So there's too many things here, and a committee should be convened with residents and commissioners to find a better way. And I do think that the tenants need relief because the courts are not sufficient to handle it. And as Commissioner Vaughn said, there are many tenants in those conditions that should not be. They need help. But now we have to figure out what's the right way to get them help. So I hope you don't charge through with this particular ordinance the way it is. I don't think it's going to solve problems. I think it's going to create more. But I do think that tenants need help. And that help could have been given many, many times in all the situations I've seen, but was withheld. Now I'd like to talk about the general land use things. And my issues on the general land use is I don't think anybody has any idea how many land use proposals there are right now. We have the 365 apartments on the mall property, again, built right next to the road. Again, more rights than what the mall owns, and nobody has sat down to discuss what would be the right thing to do with a mall owner who's filed bankruptcy. In the middle of not paying some of his people, he's off spending money building another apartment that could be a white elephant and could turn into who knows what when it has to be taken over. So there are many, many issues on that one alone. Then we have Penn State expanding for both colleges while trying to keep everybody focused on a beautiful academic building that they're building. They're actually rezoning both properties. And the commissioners do not have to entertain these text amendments that are, the Willow Grove Mall is a text amendment. This is a text amendment on the college campuses. They shouldn't entertain them until the residents have had answers properly from these particular property owners. In addition to the fact that they don't have to move forward, most residents don't want more corporate housing. They don't want more units and more apartments. And the commissioners need to hear the residents that make up the community that they're supposed to be representing. And yet, once it gets into the formal process, that will almost never happen. Like how the YMCA group was drugged through 5 different planning commission meetings, an entire year of a meeting almost every minute that they had to attend in order to protect their rights. Had it not gone into the formal process, they could have demanded certain things and not encourage their commissioners to send it to the formal process until those things that they wanted were addressed. And that's what commissioners need to let their residents know, and that's how it should be handled. So it's a shame that the people wanting those expanded rights are not really accommodating the residents with videos and with their questions being answered. They're saying, no, we're just going to go ask for the formal process. Okay, and
Ms. Lehman, you're past the 6 minutes. Can you please wrap up your comments for us?
Yeah, well, the last one I want to mention is York and Susquehanna Road, which is being done. It was supposed to be the Economic Development Corporation. That hadn't formed yet, so it seems to be being done via the Montgomery County redevelopment. The property owners were not even told that their properties were going to be presented at a planning commission meeting to be certified blighted. They were not even told. And in addition, it seems to be contrary to the law, which requires those properties to be, number one, vacant, and for them to have an opportunity to amend any problems that there are. And so this is also increase, and the development is increased density and increased housing units, which is not what the residents wanted. So thank you. I appreciate the time.
Thank you. And on that, I'll take a motion to adjourn. All right. Thanks, everyone.
Thank you. Good night.
Good night.
Hi, Liz. Night,
Good
everyone.
night. Good night.
Good night, everyone.